Joining us now is Charlie Savage, who is covering the story tonight for the New York Times, and Neal Katyal, former U.S. Acting Solicitor General during the Obama administration. Gentlemen, thank you both for being here. Neal, I'd love to start with you. I found this ruling from the 11th Circuit quite a doozy. That's not an official legal term. How did you read it?
Yeah, I mean, federal appeals judges generally talk in kind of very plain, understated language. This was not understated. This was these three judges tearing apart Donald Trump's legal arguments. And Donald Trump did get a good, lucky early break. He drew a judge initially over the summer, Judge Cannon, who seems inclined to entertain all sorts of wackadoodle arguments. But his luck ran out here, and he drew a panel that was incredibly conservative, Alex. I mean, these are three very, very conservative judges, but they basically said this is a terrible legal argument. And one quote that you didn't show that I want to share with our viewers is this. The court said toward the end that Trump's argument, quote, defies our nation's foundational principle that our law applies to all without regard to numbers, wealth, or rank. Essentially, what the court was saying is, Trump, you want some special privilege here just because you're the former president. You don't get that here. You're treated just like everyone else, and nobody else would get a special master for their criminal investigation after they stole a bunch of secret government documents.
Neal, it's an indictment of Trump's strategy, but it's also just an embarrassment for Judge Cannon, is it not? I mean, this whole thing is effectively a rebuke to her contention that she can step in and make a ruling here.
Yeah, I mean, it's about as much of a body slam as you could get. And I think one other ancillary effect, and I'm sure Charlie's been thinking about this as well, is what this does to Jack Smith's investigation. Because if you're the special counsel, you've now been handed this on a golden platter. You have three very conservative judges saying, essentially, your investigation's legitimate. You can go forward. Trump banked on the reverse. He had hoped that they would slow or stop or stymie or discredit this investigation. And all he got was 18 pages of, no way, this investigation's legitimate and it's going to go forward and investigate these very serious crimes.
Yeah, the answer is no, Donald Trump. Charlie, to that end, to Neal's point, what does this do to Jack Smith and the special counsel's timeline here?
Well, certainly it takes the handcuffs off. He had already been freed by the 11th Circuit to use, before he got there, but the people he's now supervising were freed to use the 103 documents marked as classified in their investigation. Now there's no more fetters, or there will be no more fetters when this 7-day period elapses, to using the other sort of 13,000 pages of stuff that is evidence about what this was being stored with, who was maybe had access to it, and so forth, that are all going to be adding up to the ultimate decision of whether to bring charges. I would say there's another element here that is shouldn't be overlooked, which is one of the things Jack Smith is going to have to decide at some point if he does say he's going to move forward with asking a grand jury to indict someone in this case, whether it's Trump or some of his aides, is where to bring those charges. The most obvious place to bring them is in Florida. That's where the documents were being held. That's where the obstruction happened, if there was a chargeable obstruction here, even though the grand jury whose subpoena was defied was based in D.C. And an issue with bringing the charges into Florida, however, is that Aileen Cannon could end up with this case. Under the rules down there, if some judge has already dealt with something, and then there's a related matter that is filed, either of the parties can file a motion to move that case to the judge who originally had it. The idea is to not have two different judges having to get up to speed and wasting judicial resources. Obviously, this Justice Department does not want a criminal case, if they bring one, to go before this judge. And so ordering this case dismissed at this point on such sweeping grounds, not letting her get to a new motion that the Trump people filed just a few days ago, trying to get the search warrant affidavit released without redactions, not letting her get more sort of hooks into the case, may also improve the chances that Jack Smith ultimately decides to bring charges, if he does, in Florida as opposed to in D.C.
Oh, that's a very interesting twist in all of this, Neal. Do you have an opinion on I mean, do you have an opinion on whether Judge Cannon may have seen the error of some of her ways? Because at points in all of this, she has reversed course rather quickly when effectively slapped back by other courts. I mean, do you think she continues on her course thus far charted of being a Trump defender? Or do you think that there's go ahead.
When you ask Alex, has she seen the error of her own ways? I mean, I guess if she can read, she's got to be able to see the error of her own ways, because it's 18 pages of just, you are absolutely wrong, start to finish. So I disagree with Charlie a little bit in the following sense. I think this case, if there is a criminal indictment, has always been in Washington, D.C. That's where the documents were stolen from. That's where the grand jury is sitting. And so I've always thought it was going to be there regardless. And I think the Justice Department is very, very wary of ever being seen as trying to shop for a certain judge. We've certainly seen a lot of forum shopping by other participants, but you don't see it at the Justice Department. It's one of the most kind of cardinal rules of the organization. The one kind of exception is if you do have someone who's truly acting lawlessly. And so, I agree with Charlie that this is an additional fact that the department would consider, but I think it was going to be in DC through and through, no matter what, just given the nature of these charges and where the documents were stolen from.
Charlie, let's talk a little bit about the timeline for a potential indictment, because there was some thinking that the Justice Department would have to wait until Judge Dearie finished his review. If this does not go to appeals, and if Dearie is effectively taken off of this next Thursday, do we have an expectation of what the next step is? We know that there is a parallel intelligence community review of the classified information. Do we know where that is? Do we have any sense of when this may be wrapping up?
Well, everything was a little bit on hold, of course, because we were moving through the 60 days leading up to the election, and because of this document review. And by the way, it wasn't just until Judge Dearie, the special master, finished his review. That was just going to be the end of part one of this process, because he was merely going to make a report and recommendations to Judge Cannon under her vision, and then she would start over and decide for herself and maybe have briefings and arguments along the way. The delays that her process could have pushed this case into went well beyond the timeline for Dearie to wrap up his phase of just taking a first look at it. So this really does move things along in that respect. What we don't know is how much information they still don't know in terms of missing puzzle pieces at the top level. What was Trump saying to his aides at various points in time that would show his knowledge? To what extent did he direct them not to turn over certain documents? Is he able to say he just didn't know? They're going to still be the reason why these aides of his are coming before the grand jury. And there's, I think, still many more of those interviews to be done. And just to continue the other conversation with Neil about whether it's obvious that DC would be the venue here, you say the documents were stolen in DC, but if Trump was still president before January 20th at noon, when those documents were put in boxes and taken out of the White House and shipped to Mar-a-Lago, he had every right to do that. And so it's the retention of them months later, a year later, when he's not the president and he receives a subpoena for them and he still doesn't give them back. It's the unauthorized retention of them, not the taking of them, that is the cleanest Espionage Act offense here. And that is not something that happened to DC. That is something that happened in Florida.